Yes, Miss Horlick. We're very grateful to you for coming in at relatively late notice in this case and for your assistance. Mr. Isaacs has a little bit longer.
Yes, a great deal longer, which is, but thank you very much for saying that.
Which can just be clear, your client is still incarcerated.
He is. I had hoped he would be on the CVP.
Yes, that was mentioned to me yesterday, but in the end it hasn't happened.
Yes.
Anyway, when is he due to be released?
I believe he's due to be released. I saw him yesterday morning. And my instructing solicitor who sits behind me and I understand he's going to be released within the next 3 days.
We reckoned Friday.
14th, yes,
yeah.
Apparently. If that's, I think that's Thursday.
I think 15th is probably the 21 days, but
yes.
Anyway, people do get released a day or so early or more.
Yes.
Now, as you've come in relatively late, would it be of some assistance to you if we steered you in the direction with which we're particularly concerned?
Yes, provided, well, of course, yes, of course, my lord.
I mean, you could...
I suspect I might want to say something afterwards, but if you could, I'm sure.
Oh yes, no. I mean, we are particularly focused on things that appear in your grounds 3 and 4 about the procedure which was adopted in this case.
Yes.
Mr. Isaacs will want to consider this as well, no doubt. Am I right in saying that no notice of committal was ever issued naming your client in terms as a respondent to the application?
That's correct.
What notice did your client have of his personal liberty was at stake?
Well, my submission is that he had no notice, and can I just inform your lordships about the position of Mr. Evans, because when I was instructed on last Thursday, I spoke both to my learned friend Mr. Isaac, who I must say has been incredibly helpful to me, and I'm most grateful to him. I also spoke to Mr. Evans because at that time, as you know, I hadn't had the opportunity of seeing Mr. Ahmed, so I was without effective instructions. So I wanted to speak to Mr. Evans to get his perspective. I spoke to him. That enabled me to draft the grounds and the skeleton in the way that, or the grounds in the way that I did. I have, since drafting them, sent the skeleton to Mr. Evans because I didn't want to be in the position of saying things about his position without him having had the opportunity to either to confirm or to correct me. So I have done that, and Mr. Evans has been kind enough to confirm that what I put in the skeleton is correct. Therefore, that means that we have to go back, if we're considering grounds 3 and 4, from the background point of view, to go back to the 9th of October, which was the first time that the committal proceedings came before the court.
Yes, just bear with me.
Yes.
Before we do that, the notice we've got in our bundle is at tab 16 of the core bundle.
Correct.
Is it?
That's the application.
That's the application, yes, that's what I mean. Sorry, the contempt application. And that names Landmark as the in the 3rd box.
Correct.
Yes.
And it names Landmark and Landmark is the defendant.
Yes.
So that what appears on page 3 of the form, 187 of the bundle, is addressed to Landmark. The nature of the contempt is the breach of the undertaking in box 5 on page 188.
Yes. I think it's common ground that was the payment on the 14th of December 2022 of the 57,600 to the other Mr. Ahmed, no relation.
Yes. Yes.
defendant in the case.
The undertaking as alleged to have been breached is in box 10 on 189. And the facts alleged to constitute the contempt are in box 12.
Yes, my lord.
And the only reference to your client is at, references are at paragraph 6, referring to an email sent by Mr. Isaacs instructing solicitors, and in paragraph 11 to a statement made in court by your client on the 12th of June. So apart from that, there's no reference to your client directly.
Exactly, yes.
And then attached to that, there is the affidavit of Mr. Izod, correctly. Is there anything in that affidavit pertaining to the particular issue I've asked you about? Namely, whether the extent to which this application was specifically directed to your client.
No, there isn't. And I think that has been my point throughout, that he was not on notice, that there was nothing which named him as an individual. It was all directed at Landmark LLP. Because they were the solicitors who gave the undertaking in the beginning, and they were the solicitors who at some point held the monies.
Yes.
Well, there's a different point about that. That's the point about the substance of the wrongdoing, and the case against your client, as found proved by the judge, was essentially that as a director of the LLP, you had a duty to act reasonably to ensure that the LLP did what it had undertaken to do, and that he failed to do that. But what we're concerned with here is more the question of whether he was told properly and in a procedurally fair way that was the case.
Well, I understand that, my lord, and our case is very firmly that he was not.
Yes.
Hence what happened on the 24th of November.
Let's take it, if you'll forgive me, let's take it in stages.
Yes, of course.
And I'm taking stages, so I want to give Mr. Isaacs an opportunity in due course to insert anything, not now, but insert any observations as we go along, if he feels it appropriate.
Yes.
I won't go through the exhibits to Mr. Izod's affidavit at this point, but there may be matters there. Then is the next thing that happens the hearing in October? Is there anything that you'd like to refer us to before the hearing on the whichever date in October it was?
No, I mean, there was a hearing on the 12th of June.
Yes, I know. Yes,
that was
but
a third.
that post date predates the application.
Yes, it does. It does. And I think that was listed inter alia as a third party debt application against Landmark.
Yes. All of that, what happened on the 12th of June,
Yes.
will be relevant as and when and if we consider the substance. And I'm at the moment focusing on the procedural
Yes.
point.
No,
that mentioned
I
at the
understand, my
start.
lord. I'm sorry if I'm difficult or
You're not. But so is the next thing that happens, as it were, in the committal application, the hearing in October?
It is. And can I say, just to be so that it's absolutely on the record, the reason why I flagged up that I had both spoken to Mr. Evans and sent him my skeleton is because I wanted to double check the position about representation on the 9th of October. Because my client, Mr. Ahmed, was not there
Yes.
because he was otherwise engaged in Bradford. What had happened was, as far as I can understand from speaking to Mr. Evans, that he was briefed at very short order. He had taken the view on looking at the papers, that there was a conflict between Landmark and Miss Kadri, between their positions and that of my client, Mr Ahmed.
I see a conflict between Landmark and Mr. Kadri on one side and Mr. Ahmed on the other. you
Yes.
mean?
But probably in some senses principally between Miss Kadri and Mr Ahmed. As I can't be
Anyway, there
absolutely
was a
sure, but anyway,
Yeah.
a conflict.
One can
So that-
understand that, given what she later was to say about her.
Exactly. Although some of the things she says are actually supportive of my client's position, but we may or may not need to come to that. The point is that unbeknown to Mr Ahmed, who was not at court because he had a professional commitment, he was not represented on the 9th of October.
Is your case that Mr. Ahmed thought he would be?
Yes.
Right.
And then one looks at what happened on the transcript, and it was a fairly short hearing.
Yes, we've got that at tab 20.
Yes, in a sense, it was, if one looks at it, in perhaps pages 268 and 269 in the bundle are instructive, is that Mr Evans said some matters which were not very complimentary to my client.
Where are you looking at in particular?
Let me just turn up. So it's 268. Line 13, Mr Evans. Of course, the unusual feature of this case, to put it in the most neutral language, Mr Sharaz Ahmed, who is also a designated member of Landmark Legal, appeared as counsel on the last occasion. And the judge says indeed, and then he goes on an extraordinary situation, but then goes on to talk about the money.
What is the last? When he says the last occasion, what does he mean?
He means the 12th of June,
Right, i.e. the
2023, when Landmark was represented by counsel called Miss Omar,
Yes, that's right.
and Mr Ahmed, so to speak, was representing the other Mr Ahmed, who was the defendant in the possession application, if that's exactly what it was. So
Mr. Omar represented
Landmark,
and the appellant represented
what was the defendant
the
then?
defendant. Okay. Yes.
Another Mr Ahmed.
Yeah.
But as one can see, Mr Evans, even in this short passage, is
We have to
drawing
purge our
attention to.
we. Who is we? In his when he says that, that's Landmark, is it, or is it Landmark and Miss Kadri?
Sorry, we.
Line 19. The most important.
Oh, we. Yes, we have to purge our contempt. I have to say I'm not absolutely sure what he means, but all I know is that he wasn't representing Mr Ahmed by that point.
He says at 267, line 5, I appear for Landmark Legal LLP.
Yes.
He doesn't mention anybody else.
Who are the respondents to this application to commit?
Yes.
And then he goes on, page 267, to say, we now apologise, and then to refer to Miss Kadri and Mr Sharaz Ahmed as the designated members. So he's treating we as, I think, well,
Right.
that's debatable. Anyway, he's talking about all three.
Yes. But what?
He does say he's acting for Landmark.
Yes, but what happens is he then speaks about the contempt, and then at the bottom of the page, as I think that I set out in my skeleton, he says this. The effect of that is I can, Your Honour, having heard Mr Isaac open this case, I can go on to try and mitigate. We are in the court's hands as to what is the appropriate procedure. Sometimes judges prefer to have seen the purging completed before actually passing the sentence. So in effect, he is suggesting that the judge could go straight on to sentence on that day, and presumably he meant as against Landmark. I don't think it can be read in any other way, because if it was going to be read as the designated members as well, I mean, apart from that being wrong legally, because a separate case would need to be proved against each of the designated members in my submission. In any event, Mr Ahmed wasn't there and wasn't represented, but he wasn't there. And then if you turn over the page to 269, Mr Isaac, because the judge wanted to know Mr Isaac's view about that, he says at line 7 or line 8, I would very much prefer that Your Honour does not consider sentence until after the contempt has been purged.
Yeah.
And then the judge at line 22 says that she will save that for sentence. And then the rest of the hearing is really calculation of how costs are going to be calculated, and then a discussion and when the payment's going to be made, and then a discussion about when it was going to be listed for sentence. And that was all done in the absence of Mr Ahmed.
Was there an order after this hearing?
I'm sorry to go like this.
There
Well,
was.
did I re-
There was.
I can't immediately remember where it is.
It follows the letter. There was a letter and an order.
Yes. 281. I'm grateful to my learned friends.
So it's in the email, right. Thank you. Right.
Yes, and that again, of course, doesn't mention my client by name at all. It's
It
all,
calls it the contempt submitted by Landmark, as we've
Yes.
seen. And the adjournment.
the adjournment was to allow Landmark, but actually, in the event not Landmark, to fully purge the contempt.
When you say not Landmark,
Well, what I mean by that is that it was actually not Landmark who did purge the contempt, but my client.
Well, we might come on to that.
We might come to that. So
But
that's
anyway,
why I say that.
that's his case, but
That is his
that's
case.
not the way the judge proceeded. I think.
No, it's not the way. Even though we can look at the banking records, but
All right.
perhaps we'll not get to that.
Well, we might, but
We might not. But I
following
didn't
on
want
the
to
following on the line I'm
pursue it.
pursuing, there is no reference to your client at all in that order,
No.
and the effect is there's nothing that occurred at that hearing as evidenced by the transcript or the order to put your client on notice that his liberty was at jeopardy.
Exactly. And nor, of course, was he ordered to attend the adjourned hearing.
I'm not sure that that's possible with the contempt. Though it's their choice whether to attend or not.
But if you
can always
you
order
are
somebody to attend a hearing,
But, to attend. Can't order them to give evidence, but
no,
at
but
any rate.
if you're going to be effectively sentenced, there might be some
Yeah.
suggestion that you might turn up for that.
Now, the hearing was listed till a fortnight later, but in the event that never happened.
I think I'm sure my learned friends will correct me, but I think in the intervening time, Miss Kadri served an affidavit, and my learned friends wanted to be able to cross-examine her if she was going to give evidence, and there wasn't going to be enough time. So it was then adjourned to the 24th of November.
Right. Yeah. That's the affidavit, page 282.
Yes, there are two, but there's a...
Okay. And now, between this hearing and the ultimate hearing on the 24th of November, there were communications passing various ways, including to your client. Is that right?
There was a letter from my learned friend's solicitors.
Yes.
Yes. Which,
You want to show us that?
yes, I'm going to have to find that letter.
That's 277.
277.
This is the letter to which the order is attached.
279, I think. Oh, 277.
It's the
Two
same.
copies
The
of it.
same letter.
It's the same letter in, yeah.
It's emailed on the 277.
So is that I mean, that's the first communication we've seen today directed to your client following the committal application. And now I'm taking this very slowly, Ms. Fawley. May seem
I'm
like
very
a
grateful
tortoise,
I'm doing catch up.
but that is, am I right about that? That's the first, yeah, Mrs. Isaac is nodding. Jen.
Yes.
That's the first communication. Other than that, my
With
question is,
with the exception of the skeleton argument that
Skeleton
preceded the 6th of October hearing.
okay, well, there may be other points I say Mr. Wright's going to fill in a minute, but so the letter of the 19th of October is the first communication, and nothing in there to expressly indicate that his liberty was
No, absolutely not.
in jeopardy. Okay, all right. Where do you want to take us next?
Well, as far as my client is concerned, there was, apart from this, there was nothing until he came to court on the morning of the 24th of November. And it was at that point that he was told that he didn't have representation. But he still was not aware that he was in personal jeopardy.
Why did he? Are you saying that he thought he was going to be represented?
Well, I think he thought that the company was the person to whom all the committal application had been addressed, and it was the company who had admitted the contempt.
He thought the company was the identified contender.
Yes. And he had no reason to think otherwise.
Is it your case he'd come to offer a personal explanation or apology?
Yes, because
requested in the letter from
you can
Isaac.
you can see that from, in fact, the transcript of the hearing on the 24th. I mean, there are some other matters that I wanted to point out from that. Certainly, if one looks at page 360, which is the beginning of this hearing.
Right.
Where it's, well, at the top of that page, 360, Mr. Isaac makes clear that Mr. Evans is only appearing for Miss Kadri and Landmark Legal.
Yes. So by this stage, Mr. Evans is acting for Miss Kadri.
Yes.
The respondent's skeleton argument, paragraph 34, says that the skeleton argument for use of the adjourned sentencing hearing was sent to Mr. Evans and the appellant on the 23rd in the afternoon of 1424. Is that accepted?
No. well, in any event, he still was not on notice. But the point is that following the letter that he was sent on the 19th of October, if one turns to page 361, which is still right at the beginning of this hearing, the judge at the top, well, sorry, at the bottom of 360, I'm sorry to jump around, Mr. Isaac says this is effectively a sentencing mitigation hearing. So that seemed to be the anticipation of the parties. And we suggest for Landmark, and that was what Mr. Ahmed understood. So if you turn over to page 361, Mr. Isaac is saying the appropriate thing to do is for Miss Kadri to be cross-examined, Mr. Ahmed, if he wants to give evidence. And then the judge said, well, I probably ought to hear from Mr. Ahmed as well before we do that. And then Mr. Ahmed says, yes, Your Honour, yes, Your Honour has the background. We are effectively attending, that is two-part, that's the two directors, myself and Miss Kadri. And he goes on to say a little bit further down, yes, and I have attended in order, well, firstly to offer the apology to this court, and secondly to assist with what I can in this sentence hearing. So that line, if nothing else, demonstrates that Mr. Ahmed simply had no idea that he was facing any personal hazard or any sentence as far as he was concerned. Although, of course, in my view, he couldn't possibly be facing a sentence when there had been no fact-finding hearing in relation to him.
May I just take you back a moment to Mr. Isaac and Mr. Wynne Smith's skeleton for this hearing in November. So it's the previous tab.
Could I ask Your Lordship for a page number?
Yes, well, it starts at 340 something, and I'm looking at the. It starts off by dealing with the material facts.
Yes.
Your clients mentioned in that summary various things once or twice, and then it talks about representatives. Then it goes into the law, and including the Olympic Council of Asia case, obviously important background, other cases. And then he comes to application of principles in this case. And he identifies, he applies very properly, applies the facts to the principles. So he's got the principles in italics. And at B, he says whether the contemnor has acted under pressure from another. That's one of the factors identified in the authorities. And that's all about, and his comments about that are all about Landmark as the contemnor, as I read it. And then D, the degree of culpability of the contemnor, another principle to be relevant to sentence. And again, he's obviously talking about Landmark as the contemnor, but at this point, he refers to your client and your client's actions or alleged actions or omissions in identifying the degree of culpability of Landmark.
Yes, my lord.
And there are various references to what your client is said to have done, and as the judge found had done, in substance, to a very large extent. And then in mitigation, E, it's all about Landmark again. And then in conclusion, he refers to the aggravating feature of your client's role. Do you have any submissions about that?
Well, it's still all directed towards Landmark, ultimately, as being the contemptor, as opposed to the designated members as individuals. Because the legal position is, I would suggest, that even if the LLP was found to be in contempt of court by the payment, the authorisation of the release of the funds on the 14th December 2022 back to the original defendant. And I might add that the only person, according to Miss Cadry, as opposed to my client, who had authorisation to do that was herself. The law is that even if that was the case, that Landmark LLP was in contempt of court, that there would then have to be a separate consideration as to whether the each designated member as a quasi-director was in fact in contempt individually themselves. I think Mr. Evans quite properly and fairly summarised the law in relation to this in his skeleton argument.
Would you just refer us to that?
Of course, it's at page, sets out the law starting at page 340, paragraph 6 of his skeleton argument. Around 5, actually.
Do you have instructions on whether your client had a copy of that skeleton argument, Mr. Evans' skeleton argument?
No, he didn't have a copy of that skeleton argument.
And I think you said that was your case also about Mr. Isaac's skeleton.
Yeah, he didn't have either.
Before he arrived at court.
I'm not sure he even had it when he arrived at court, to be fair.
Which paragraph in Mr. Evans' skeleton were you? Was it paragraph 5?
Yes, but in fact, if you look at page 342,
Right.
that's probably the most.
Is that a citation from Mr. Justice Hamlin, as he then was?
Yes. So paragraph 24 of that judgment, Justice Wolf. In our view, where a company is ordered not to do certain acts or gives an undertaking to like effect, and a director of that company is aware of the order or undertaking, he is under a duty to take reasonable steps to ensure that the order or undertaking is obeyed. And if he willfully fails to take those steps and the order or undertaking is breached, he could be punished for that, for contempt.
The part of that citation which I focused on the issue that we're looking at is the citation from Mr. Justice Briggs, as he then was.
Yes.
In the sector guard case. Paragraph 42. I think it's all set out by Mr. Justice Hamlin.
So they must disclose in the committal application
That's right.
a case for the establishment of responsibility on the part of that director, either on the grounds of aiding and abetting or willful failure to take reasonable steps to ensure that the order or undertaking is obeyed. I imagine that in that sort of situation that the committal application is directed towards an individual director. So at least they would know in the application that they were the object of that application and what the case was against them.
That wasn't a point that Mr Evans took on behalf of Miss Cadry.
No.
Well, that may be, but
No, I'm just, that's correct as far as we can tell.
it is as far as we can
What
tell.
one draws from it is another question. But,
Well,
I think the problem with Miss Cadry's position was that she was in a supervisory position, and she also was the only person who could authorise the release of funds from the bank account.
well, yes, but procedurally, it looks to me, and you'll correct me if you think I'm wrong about this, that a decision was taken that whatever procedural objections might be raised on behalf of Miss Cadry, they weren't going to be raised, and Mr Evans went straight to the merits of her position.
But I mean, he was, I think, clearly instructed at the very last moment. But he, for one reason or another, he took that decision, and it may have been from a practical point of view, perhaps a good tactical decision, but that is actually skipping over, so to speak, what should happen in cases such as this. And I think this is the problem, because in a sense, the judge, who may well have been inexperienced in committal proceedings, and they're not that common, I imagine, in the county court, that in a sense, she seems to have equated the admission of a breach on the part of Landmark to proof against the designated members, when that cannot be the case, because the law is that there has to be a separate consideration, and proof of contempt has to be on the criminal standard.
right. Mr Evans seems to have proceeded on the basis, not taking the procedural point, but to accept that his client was at jeopardy. Looking at what's said at 344.
I agree, he has taken that point. I mean, he was instructed by Miss Cadry, so clearly we don't know what happened behind the scenes.
Right. Now, going back on, what else do you want to say to us about what happened at the hearing on the 24th of November? On this point.
Well, my point is that if we go back to the transcript, so I think I was at 361, where I'm saying that Mr Ahmed, in the middle of that page, says, I've attended to, well, firstly, offer the apology to the court, and secondly, to assist with what I can in the sentence hearing, that indicates that he was not on notice that he was in any personal jeopardy at all, that he was assisting as far as he could in terms of Landmark. And then the judge, who, I mean, rightly or wrongly, seems to have taken it rather again, Mr Ahmed, starts asking him what he's apologising for, and he starts by saying, well, and then he gets no further, because she says, because you didn't attend the first two hearings of this. And there's some discussion about that. And then at the top of page 362, having apologised and said he was sorry if the information wasn't communicated to her. I cannot assist any further, I just apologise. Directions were made by this court, and those directions in terms of ensuring that the monies and costs were paid of a portion, that was done on time. And then she seems to turn away from him to Mr Evans, and asks whether he wants to call Miss Cadry. There seems to be no further exploration as to why he's there without any representation, or to really inform him at that point as to what was going on. I'm not I'm not trying to blame the judge, because I think that this was a series of misunderstandings which led to a situation where Mr Ahmed was bounced into a situation where he simply wasn't anticipating it.
Right. Well, so if we go on through the transcript, we
Yeah.
see Miss Kadri gives evidence, and she's cross-examined by Mr Isaac.
Yes.
That goes on for a few pages. Quite a few pages. And then we get,
Because she's cross-examined in quite some detail about the events around about the breach of the undertaking and who was writing letters in her name and who in fact could authorise the transfer of the funds.
I moved, yes,
Yes.
I moved over to page 374, but is there anything that you wanted to, did anything happen in that cross-examination to indicate that Mr Ahmed's, the appellant's liberty was at risk?
No, nothing.
Okay, so then we get to the she's released, and then the judge turns to your client.
She does, and she says this, doesn't she, at page 374, which is the part that I picked out, I think, of my skeleton. It's been an acceptance. Now, I want to make sure you understand the position you are in as well, Mr Ahmed.
Yes.
Yeah. There's been an acceptance by Landmark Legal that it was in breach of the undertaking. Clearly, that's a very serious matter. It was an undertaking that you gave to Her Honour Judge Evans Gordon in 2019. Well,
So really,
he didn't
here
actually
she
give it.
spells it out. I'm moving you on.
Yeah.
This is where she spells it out to your client on 374 towards the bottom that he's at risk.
Yes. But I mean, what she does, I mean, apart from it being wrong in law, because she says that contempt has been accepted, and that could mean that either one or both of you get sent to prison or fined, and it certainly means, certainly given the evidence I've heard so far this morning, that my judgment would be sent to the SRA, which of course wouldn't apply to Mr Ahmed because he isn't a solicitor. And then she says, I know you weren't here the last time. If you want to have a few minutes to think about it, then you can do so in respect of giving evidence. So she gives him a few minutes to think about giving evidence. But frankly, that's all. Maybe because she is under the misapprehension that he understands what's going on. But then she's also under a misapprehension about the law. And then he takes clearly a very short space of time, and then he comes back.
And he answers the question about he won't be giving evidence.
He won't be giving evidence. And then he starts to try and make what he regards as being some points. I have to say, my lords, that this is really a paradigm example about why lawyers shouldn't represent themselves, frankly. But
So he gives evidence in submissions.
Hmm?
He gives evidence in his submissions.
He
effectively.
does.
Yeah.
Yes. And then,
Which is a great way to do it because you can't be cross-examined.
I can't imagine that that's...
I don't think that's a very good example in case anybody behind is thinking that the law was giving.
That was an example of irony.
Right.
It was like, have you ever done those Privy Council cases where they made statements from the dog?
Yes, quite. It was once allowed.
It was once allowed. Never a good idea.
Right. Okay. So now.
Anyway, but he says the points I make are simply these from what we've heard from Ms. Kadri this morning. I set out the principles of reliability of directors of designated members. Some length for my skeleton argument. I don't know what that. Oh no, that's Mr Evans. I'm really sorry.
So Mr Evans,
Yeah.
Mr Evans makes
Mr Evans makes
and
then he Mr Ahmed is at page 377. And when he moves to the front, he says, if I can perhaps just start off with this, Your Honour, perhaps working backwards in light of what transpired. Sensible course of action was to purge the undertaking.
that's a breach.
That was done within my reasonable submissions, done within a short period of time, and the timetable was commissioned by the court. But then there was then talk about compensation or interest. And then at middle of page 378, he starts to say this: the evidence of Miss Kadri was quite clear. Counsel has drawn you to the relevant parts of Miss Kadri's evidence. Well, in fact, there were very relevant parts of Miss Kadri's affidavit and evidence as far as he was concerned about his role. I don't need to draw your lordship's attention to that at the moment, but I could do. And then the judge effectively interrupts him and says, I'm not so interested in your comments on Miss Kadri. Is there anything you want to say in respect of yourself in mitigation? Why I should not send you to prison as being a member of this solicitor's firm? So this is mitigation. There's nothing about, it has to be proved against you to the criminal standards. What do you want to say about that? So it's all to do with mitigation, and it's not allowing him really to make, or interrupting him when he's trying to make on the hoof comments about Miss Kadri's evidence and the importance to his position. And then he does at the bottom of the page say something about the control within Landmark, saying it was within the control of the people who were there, a woman called Anita, who's not a qualified solicitor, and Miss Kadri. And at the bottom of the page and over to the top of the next one, that he had no involvement. And the judge then interrupts him again, saying, are you not a member then? And he says, I am a member, but I have a limited role and I think. She interrupts him again. So do you have an equal responsibility then as a member of the limited liability partnership? And he says, well, from a practical point in terms. And she says, well, I'm not asking you from a practical point, Mr. Ahmed. I'm asking you from a legal point, which again is not correct in the circumstances of this case, but leaving that to one side.
So I think your submission is that the judge was treating his role in the organisation as sufficient to fix him with responsibility for the contempt which had been invented by the organisation.
Because he was a designated member. And that's why she's asking him to address her on mitigation. Why it was billed, so to speak, as a sentencing hearing. And Mr. Ahmed says, well, it may be a matter which Your Honour is minded to refer the matter to the SRA. Well, that's from Landmark's point of view, because he can't be referred to the SRA. But from the practical position as it's been presented, I'm not authorised to make any payments.
He can't be referred to the SRA because he's not a solicitor.
Not a solicitor.
He was
So
at some stage a solicitor, I think. If I picked it up correctly.
That's not my understanding. I did check this specifically.
Your cases, he was a barrister.
He's been a barrister since the year 2000. I mean, as I'm sure your lordships know, there are some barristers who have
Dual qualifications?
No, not dual qualification, dual capacity. So you can be both a barrister and an employed barrister.
Yeah.
You can have a role within a solicitor's firm, but as a barrister, not as a solicitor.
So your case is that he was a member of the LLP and a barrister.
Yes.
But not a solicitor
But not
at any
a solicitor.
material time. Whether he was at some past time doesn't really matter.
Yeah.
Right. So really,
and then
his address to the court is just on these pages. These 2 pages, and they finish at 379.
yes, so the middle of 379.
Okay. All right. And then Mr. Isaac.
And then Mr. Isaac.
Okay. Right.
it is, if one thinks about it, very difficult to believe that someone, if they had known they were in some kind of personal jeopardy, would have turned up at court without representation and without seemingly any kind of preparation or production of any kind of documents whatsoever. I mean, Mr Ahmed's been a barrister for 23 years. In my submission, all of the evidence shows that he was effectively blindsided by what happened on the 24th of November. Now, it's all very well for my learned friends to say, well, he could have asked for an adjournment, he could have said he was ill. Those are all correct, but it doesn't take away from the fact that he turned up on that day without being given the notice he should have been given that he was in personal jeopardy. And then the way that the hearing proceeded, it was without a proper inquiry into whether he was, in fact, in contempt of court himself personally, proved to the criminal standard. And the hearing was not conducted in a way which was conducive, or it wasn't conducted in the way that it should have been, if that is what was going to happen on that occasion.
Right. So now we've focused on that particular issue at our request. That, as I read it, it features in part of your ground 3 and overlaps a bit with ground 4.
Yes, I'm sorry about that, but they do rather bleed into each other. If we're with you on ground 3 and 4, it would be open, I suppose, and would allow the appeal on that basis. It would be open to the claimants to seek to commit your client, to issue a further application to commit your client on the merits, relying on the matters which are all over these papers. Yes, in my submission, I would absolutely not
So
stand in the way of that.
In those circumstances, I wonder whether it would be appropriate for us to make any comment on the merits or make any findings on the merits.
I would suggest not, my lord, because in my submission there should be a de novo hearing. Well, there should be a committal application which is directed at Mr Ahmed himself, and there should be a de novo hearing. I would suggest not in front of the previous judge. Obviously, if your lordships want to make comment, I cannot clearly prevent you, but it may be better to have, in a sense, a clean start.
Well, I think. Should we ask? What should we do? Ask to give brief submissions on the other grounds or leave? To this point. Okay. Well, I think we may want to hear what you have to say on the other grounds and the substance of the matters. But at this stage, I think we'd like to hear from Mr. Isaac on the points we've raised and you've been so helpful with. Thank you. Yes, Mr. Isaac. Are you content to proceed on that basis?
Yes, absolutely. Thank you. Lord, so I fully understand your focus this morning. I think it's fair to say, rightly or wrongly, and your lordships will no doubt say wrongly, that the initial application is addressed to, it's made within the current proceedings as it's supposed to be, it's addressed to Landmark Legal LLP. But on the basis, on the understanding that an application against a limited liability partnership follows the same pleading rule as claims against a firm, namely that you can either name the individual members of the firm or you can name the firm. It's the same difference.
Well, don't you? Yes, okay, but if we're looking at a committal application, doesn't that have to be directed at the? If it is intended to be directed at an individual, shouldn't the individual be named as well?
Well, we were, and again, rightly or wrongly, we were being very careful not to force the court's hand in any way, to leave it, because committal is contempt of court, and it's all about the court's role and the undertaking given to the court. We were being very careful, and I say rightly or wrongly, not to attempt to prejudge the court's view as to what the appropriate sentence was, and certainly all the authorities talk about that. So
Yeah, well, that's right. That's why I didn't ask you to respond to the grounds on the original grounds.
Yeah.
The directions I gave last week
we're limited,
to the substance, not to sentence.
And we would say, I do understand your Lordship's focus, and particularly asking, well, when did the appellant become aware, or when should he have known, if he should have known? And you've gone through each of the various stages and said, well, should he have known at this stage? Our view was that he was on notice from the outset that this included him.
Well, I did say that we would have an opportunity to fill in any gaps as we
Yes.
went
So
through the chronology. Is there any document you'd like to draw to our attention to support that?
well, so the I think it's fair to say that Mr. Izod's affidavit doesn't really hone in on the appellant.
Well, would it be fair, being blunt, Mr. Ahmed, to say your client's principal concern was to get the money back?
Well, it was part of their concern, but they also, and certainly it was the primary.
Yeah.
Yes,
I mean,
primary, I think it's fair to say. But the secondary.
your
point-
client's case was an outrageous. You depended on the undertaking. These proceedings have been dragging on for 4 years. Arrears of rent had mounted up. You has proceeded on the confident assumption, this is your case, that the money was being safe in a solicitor's client account, so that as and when the proceedings came to an end, your financial position was protected. And you discovered that wasn't the case. You're £57,000 out.
All of that is correct. All of that is correct. But in addition to that, we were, my clients particularly, were outraged at the conduct of the appellant, who had been counsel throughout for the other Mr. Ahmed, who had given the undertaking, who had been at court when the order was made, had then, after the money is released by his firm, Landmark Legal, personally receives part of that money as payment to himself. So yes, my clients were outraged.
Well,
And frankly, I think it's fair to say my own friend and I were.
I'm not sure that's an appropriate submission, but
No.
leaving your clients a bit outraged, then why it's perhaps more striking that outrage didn't find itself manifested in the particulars of
And this
in
is where
the
I've said,
application.
that maybe it's an error on our part for not naming the appellant and Ms. Cardry personally in the application. But we were being very, as I say, we were partly relying on the pleading point that naming the firm equals naming the members of the firm. And we were partly not wanting to breach the rule that we should not encourage the court to any particular sentence.
Why does naming Mr Ahmed as a respondent to the application to commit in terms and particularising his what you describe as outrageous behaviour influence sentence any more than submissions that you subsequently made?
Well, it might not, I accept it might not.
And as far as the firm is concerned, I mean, we're familiar with the way that civil proceedings against unincorporated firms, partnerships operate. But this was an incorporated partnership.
Correct.
And the authority that was cited in the skeleton, the decision of Mr Justice Foxton, holds that they're to be treated as equivalent to companies. So they have a separate legal personality.
Correct.
That rather supports the view that the better way,
I
not
accept.
the only correct way.
Well, indeed,
would
and
be
I
to
certainly I accept
name
in
the separate legal
retrospect.
personalities.
Certainly, I accept in retrospect. It would have definitely been preferable to name the appellant.
Yeah, right. In retrospect.
In terms of, and you've already.
And isn't that? And I think the Olympic Conservation case, which established that the liability can exist for people in Mr Ahmed's position, in that case, the claim was brought against. I think the claim was they were identified in the application.
I think that is correct.
Yeah.
They were, my lord.
Yeah. And Mr Justice Briggs, passage in Mr Justice Briggs's judgment in Secure Guard, cited by Mr Justice Hamlin in his case, makes that point too.
I'm sure it makes that
Not
point.
that particular point.
Not
okay,
that particular point. It
it
makes the
supports.
point. It makes the point that the director has to have a responsibility in some way.
So I think he makes a pleading point.
Which
as
is
well,
the
Make a pleading point. I'm
which
sorry.
is that
Justice
the,
Briggs
the
makes a pleading.
application should set out the particulars, so that the argument against you would be,
Yes.
in this case, that if you're going to invite an inference of personal responsibility in the form of willful neglect of the duty identified in the authorities, like Tuvalu, particulars need to be set out in the application.
Yes.
So the challenge, the challenge we put to you is that the point that concerns us is he's not named in the application. And the particulars in the application aren't focused directly
No.
on
no,
the
those-
specific points which you have outlined for us again. I mean, do you want? I didn't write them down as you were listing the things that concern. Do you want to say that again? As I
Well,
was,
so I mean, these were. I think they're reflected in.
they are. But if you want to succinctly summarise them for us.
Well, succinctly summarised, the appellant was both counsel and a designated member of the respondent when he gave the undertaking to the court. He was there at the hearing where the order was made, which should have as a consequence led to the release of the monies to my client, i.e. that's December 2022. He was copied into the correspondence in which we sought the release of those monies from the respondent, did not correct the respondent when it subsequently on the same day or the following day emailed to say there was no undertaking.
Was he copied into the reply?
He was copied into the reply as well.
In the reply all.
The monies were subsequently released. We've had accounts from Miss Cardry as to what happened with that, but let's just gloss over that for the moment. Monies were released, and then subsequently £9,000 of those released monies were paid to the appellant in respect to.
In the other, as at 12 Bridge,
Yes, at number 12 Chambers.
number 12 Chambers. I Number
Yes.
12 chambers.
So that was, the inference is that was for the defendant's fees as counsel.
Correct. That's the inference, yes. When this, well, the fact of the release of the monies was not even disclosed to our clients until
Of the
Friday.
Of the 57,000.
The 57,000 was not disclosed to my clients until June 2023, the Friday before a hearing on the Monday for a third-party debt order. At that hearing, the appellant denied, well, suggested that
He was there.
He
at
was
the hearing.
there.
He
He
attended.
was acting as the other Mr Ahmed's counsel.
for the defendant.
He asserted that there was no undertaking, was no longer an undertaking. There was no breach of the undertaking. And when the application was subsequently made for committal, zero response from him.
Was he served with it?
Personally served, no, it was served on the firm, served on,
So
on the Landmark.
he wasn't served personally, but never responded.
Never responded, and
You would,
including
you would and did invite an inference that he knew about it. even
well,
though not served.
absolutely. In fact, I'm not sure. No, we served on him because he had been the architect of everything in relation to this case. He had been the sole point of contact with us throughout. We served our skeleton just prior to the October hearing, the 6th of October hearing, 9th of October hearing, on him, not on Miss Cudry, not on Landmark separately. We served it on him, and subsequently we certainly did not know what is now asserted on his behalf, that he didn't receive Mr Evans's skeleton. We didn't know, nor did the court know on the first hearing on the 9th of October, that Mr Evans was apparently not representing the appellant.
You didn't know that
No.
until Mr. Evans stood up.
Well, no, until Mr Evans' skeleton on the 23rd of November, before the 24th of November hearing. Sorry.
You were.
Oh, sorry, October. Sorry, the skeleton was served. Mr Evans' skeleton was served on the 23rd of October.
You didn't know until
that
you
point.
got Mr. Evans' skeleton that he wasn't acting.
Correct.
And that was served on the 23rd of October,
October,
before the
yeah.
hearing that was eventually
On
adjourned.
the 24th of November, yes.
Okay. All right. Okay.
So that's not
All right.
as succinct as you might have liked.
No. Well, it was. Well, there was a lot you had to say. Right. So then, what else do you want to say on these points?
Well, the substance of your lordship's concerns are obviously the extent to which the appellant knew that he was in jeopardy.
Well, I mean,
That he was the subject of.
I think the substance of our concerns is that the rules are very clear about the procedural hurdles that have to be overcome when making a committal application. The procedural requirements are quite clear. And we're concerned that they've not been complied with in this case, that he wasn't named as a contender, and that that his specific responsibility, or the basis upon which he could be committed, was not spelled out in the application, nor was it the focus of the evidence support of the application. There are references to his conduct in the evidence, Mr. Izard, to some extent, and there are references in your skeleton arguments, but they're not, as I've put it to Miss Horlick, they seem to be focused more as as evidence to support Landmark's contempt, the application against Landmark, than any specifically
I might
directed
accept
to
that
him.
generally. I wouldn't accept that in relation to the skeleton
Well,
on
can
the
we- do you want-
23rd.
Okay, do you want to
Yes.
come back on that?
Um,
The skeleton for which date?
this is the last
For
skeleton
the November hearing.
for the November hearing. Yeah.
Okay.
So
Is that at 347?
I think it's no. Oh yes, it is. Well, in fact, let me go to the earlier one then first. Let's take the one which appears. Yes, which preceded the 6th, which preceded the 9th of October hearing,
Okay.
and one on the 6th of October.
Where's that?
So that starts at 256 tab 19.
Okay.
But when we're talking about application of the principles to the case, and 38D, the degree of culpability of the contempt law, the degree of Landmark culpability could not be more serious. It operates as a solicitor's firm and
Sorry,
through
forgive me, where are you reading from?
264, the top of 264.
Oh, sorry.
It operates as a solicitor's firm and through its agents, in this instance, Mr Sharaz Ahmed. It is understood perfectly well what took place and the importance of the undertaking given to the court. Moreover, the representative in court, Mr Sharaz Ahmed, was a co-director and a person of significance.
I mean, this is repeated, isn't it? Actually,
This is effectively repeated in the later one, yes.
yeah. I mean, okay. So it's all. So and in fact, yes, that's the very passage. I think it's probably cut and pasted into your second skeleton.
There's a bit cut and paste.
So the points that we were highlighted earlier
Yes.
at 354 were made in the previous skeleton at 264.
Yeah.
Right.
Yeah, indeed. I think that's fair. But my point is that Mr Ahmed, the appellant, had that on the 6th of October.
He did, but well, was he at the hearing on the 6th of October? I can't.
No, he didn't attend, but he was sent the skeleton.
Sent the skeleton. Okay, so that he was sent, your cases you were sent that. I think your cases.
Well,
you were sent that.
it was only sent to him, so the fact that Mr Evans
Because-
had it,
okay.
the inference is that.
That's right. Sorry. Yeah. Let me just-
And indeed, the later skeleton on the 23rd was also sent direct to the appellant. My learned friend says he hadn't seen that, but we sent her an email which contained our email of the 23rd of November to Mr Evans and to the appellant, containing that skeleton.
If I've got that wrong, I apologise.
It's not a significant one.
Unsurprising, given your late arrival in the case this morning. But okay, well, just then looking at the 364, so the degree of contempt. This is under the heading the degree of culpability of the contempt law. The contempt law is Landmark.
Sorry, what page are
364.
364?
No, forgive me, 264. I'm so sorry, 264. So we've already looked at this, the substance of this when we were looking at the later skeleton. We're looking into it again in the context of what you're now saying, that Mr Ahmed had this before the October hearing, even though he didn't attend the October hearing. This passage on 264 comes under the heading at the bottom of 263, the degree of culpability of the contempt law.
Yes.
That is
Which is
Landmark.
Which is Landmark.
And you say the degree of Landmark's culpability could not be more serious. And then, as I remarked earlier, this is where you really set out a
Start
number
laying
of the points,
into, indeed.
a number of the points about Mr Ahmed. And you say the overlapping role of Mr Ahmed increases the culpability. So that's the way this is framed is that Mr Ahmed's acts and omissions, some of which you referred to here, but you set out in more detail to us a moment ago, increase the culpability of Landmark.
It's true. We then, it's fair to say in the later skeleton, which is the relevant parts of which are at 354, we focus more on Mr Ahmed.
We'll come back to that in a minute.
Yeah.
But in mitigation, again, you talk about Landmark's done nothing to mitigate.
Correct. That's fair.
And so you say that when we get 354, you focus more on Mr Ahmed.
We do.
Let me just have a look at that.
some of it is cut and pasted, you're correct.
Yes, there's nothing wrong with cutting and
No,
pasting.
sometimes it's used.
Even judges do it occasionally, carefully, but occasionally. All right, so there's
So
a bit more.
there's a bit more. So particularly, so at D, this is 354D2. Having breached the undertaking, it then appears that Shahraz Ahmed was complicit with Zahir Ahmed in the dispersal of the 57,600. Number 12 chambers having received £9,000 of the money from Zahir Ahmed.
Yeah, well, in fact, yes, 2 and 3 and 4 are all new, aren't they? 2, 3 and 4 is all
Yeah.
new, that section. Okay. Right. Right.
But those are the documents I think it's fair to say I'd like to draw your attention to.
Right. Do you want to make any further submissions on the procedural point? If we're with Ms. Horlick on the procedural point, what course should we take about the other points, on this, namely the merits, the substance, as it were, rise in the other grounds? Should we say nothing about that? Because, as I said, if we allowed the appeal on the procedural grounds alone, it presumably would leave it open to you, if you thought it appropriate, to file a fresh application against Mr. Ahmed.
That's correct. I don't have a strong view either way as to whether you should express views. It might be considered helpful to the judge subsequently hearing any such application. It might not. I think that is really a matter.
But I mean, against that is the point that we would be making a passing comments on the merits of a case, which we would find Mr. Ahmed had not had a fair chance to defend, and hadn't therefore put forward.
If that were, yes, if that's.
I mean, there's nothing about Mr. Ahmed did put nothing forward in mitigation.
No.
In his, even when the Judge George spelled it out in trenchant terms, which I can well imagine her doing. He said nothing.
No, he did.
So
he said nothing. I mean, he's said various things here upon which, in a witness statement, which have not been.
Well, we haven't looked at the material
okay.
that's come subsequent. I mean,
Oh, very well.
we have looked at it, but we haven't talked about it.
No. One might say that the better course would be to say nothing, but I'm not going to express a strong view either way.
Right. Thank you very much. All right. Now, do you want to hear from me?
I think we shouldn't say anything in reply about this point.
Do you want to say anything in reply about this point at this stage?
About the last point that you asked Mr. Isaac
Well, about the procedure, about the grounds we've been focusing, your grounds 3/4,
yes.
and about the last point, the point covered in the last exchange, my last exchange with Mr. Isaac.
I don't think I want to say any more about the procedural point. The procedural points were entirely breached. I mean, it may well be inadvertently. I'm not casting aspersions on my learned friends at all, but they if it was going to be a committal application, we know how serious contempt of court is. People, as we know, Mr. Ahmed, who's currently sitting in HMP Wandsworth, the committal application should have been directed to him. His name should have been on it. I don't think I want to say any more about that. As your lordships have said, there are very strict procedural rules about that. As to the last point about whether your lordship should say anything about the merits, I would urge you not to, for a number of different reasons. There are, I think, some good defences actually to what happened in relation to this contempt. And in addition, there is a great deal of mitigation if it ever came to that. But I am very much in a position of playing catch up, as your lordships know. I've had the opportunity of 1 hour in prison with Mr. Ahmed yesterday. There's clearly a lot of evidence and material that could be gathered. that needs to be gathered, and I don't want to be in the position of having to, in a sense, defend what happened without having all of the information and all of the evidence available to me.
Well,
I don't have Mr Ahmed here.
Well, we've got a flavour of what a future application would be.
Yes.
When Mr. Isaac says that Mr. Ahmed was the architect of the whole thing,
Well,
and
I would strongly
you-
refute that.
so he
but
and you would want to put things forward,
I certainly would.
drawing on the Olympic case and the other
Yes.
cases as to what exactly your client's role in the whole thing was,
Yes.
which would be relevant both as to contempt and any sentence if contempt was proved.
Indeed, yes.
Should we get some? Yeah. We're going to rise for a few minutes to consider what caused the vote. Thank you very much.
All right. All right.
Well, we're going to allow the appeal on ground 3 and order Mr Ahmed's immediate release. And we'd be grateful, Ms Horlick, if you would draft the appropriate order to ensure that your client is released as soon as possible.
I will do, my lord. Thank you very much. That's
We're
great.
allowing the appeal for reasons to follow at a later date rather than today. We think it would be best to give the matter careful thought as to our reasons, bearing in mind the complexity of the issues that have been put before us. We don't propose to say anything about the other grounds, nor to invite any other submissions on the other grounds. I don't know whether the reasons the judgment will come out before Christmas or not now. When it does, you do get our draft judgment. We'd be grateful if you would then consider any ancillary matters, including costs, etc. And we'd like your written submissions as to the terms of the order when you send back any corrections to the draft judgment.
Thank you, my lord. But you'd like me to draft an order which would affect his release from prison?
We're making an order today that he be
Today.
released from prison.
Yes.
There'll be a supplementary order, ancillary order dealing with
With costs, I'm sorry.
costs, and there may be other matters that we haven't arising out of the complexities which we've not talked about. And we'd like you to either agree those matters, or if you can't agree, to give us short written submissions covering them.
I think the order will have to say that the appeal is allowed.
Yeah,
Yes.
And whatever direction is necessary to the governor,
yeah.
I think that's the way it works, to direct the immediate release. There are sometimes practical difficulties about that, but they'll have to be confronted.
But we're putting the ball in your court to find the appropriate way, if that's all right.
Yes,
Ms.
my
Warby.
lord,
Is
yes.
that all right? Obviously, as you know, when we send out our draft judgments, that's for the purpose of you identifying typographical and minor factual errors, not for re-arguing. Please bear in mind the rubric at the top of the judgment.
I wouldn't dare.
I'll pass that on to the Master of the Rolls. That's he'd be pleased to hear that.
If this, I'm not sure this is. I had exactly the same reminder a couple of weeks ago when I was before a differently
Yes,
constituted
well.
court. Do people really make additional submissions?
Oh yes.
Oh yes.
Too?
Oh, people make additional submissions, but people also the point of the reminder is to draw your attention to the rubric at the top and the confidentiality.
Yes.
That's why we read. That's the particularly important thing: the confidentiality of the draft judgment, because there have been cases where the draft judgment has been disclosed. There've been unauthorised disclosures, which are contempt of court. And we don't want another allegation of contempt of court in this case if we can avoid it. Anything else?
No, thank you, my lords.
We're enormously grateful to you and to Mr. Wynne, all three of you, and to those who sit behind you, for the work you've done to enable this not straightforward case to be dealt with smoothly and efficiently. So thank you all very much.
Thank you very much.
All right. I'm taking my file.
Just